Welcome to the Probate Nation. My name is Richard Ruddy. Probate is a process to transfer the title of probate assets to the beneficiary of a deceased person. To do so, you may have undertaken to get yourself duly qualified to probate those assets, and that authority works for probate assets located in the state where the decedent resided at the time of death and probate was initiated. Unfortunately, that authority does not automatically extend to probate assets in another state, such as real estate from a prior home not yet sold or a beach house that was a second home. That authority, however, can be acquired through a process called Ancillary Probate administration in the state where the assets are located. In the show tonight, we will learn the nuts and bolts involved in undertaking an ancillary probate in California, from how to initiate, steps to be taken after qualification, and how to wrap up the ancillary probate. With us is a California attorney who will share his expertise and guidance on this topic. Our guest is the founder and managing attorney of the Cali Law Professional Corporation, a boutique estate planning, probate, and trust administration law firm located in Los Angeles, California. In addition, he serves as a CASA, which is a court-appointed special advocate for children within the foster care system. His practice involves combining his skills as an attorney, real estate broker, and certified master financial coach to help clients build wealth, protect loved ones, and create lasting, meaningful legacies. Please welcome California attorney Mark Garlett. Hi, Mark. Thanks for coming back to talk to us about this particular topic.
Hi, Richard. Pleasure to be with you again.
Sure. So let's do a little bit. We're going to talk about ancillary probate, and I want to get an overview. So tell us a little bit about what is ancillary probate.
Sure. Ancillary probate in California means that someone has either died in California and we need to do an ancillary probate out of state because they have assets that are out of state, or the converse of that. They have died out of state and they have assets that are in California.
Okay. Now, what assets typically need to be probated in California by a non-resident decedent's estate?
So generally that's going to be real estate, and then any other personal property that is usually going to be part of that out-of-state probate, and it can get a little dicey there, and whether there's vehicles or those kinds of things. But for the most part, we're looking at real estate as kind of that big driver.
And who would undertake to do the ancillary probate work in California?
So generally that's going to be the personal representative of the main probate is going to reach out and find somebody in California, usually an attorney, to kind of help them. But oftentimes that's going to be that same personal representative who's handling the main probate.
And if they can't do it, sometimes would they also ask an attorney to step in and go ahead and be the ancillary administrator?
They can do that too, or they can appoint somebody as an ancillary administrator if they're willing to do that job, yes.
Okay. So let's talk about how we initiate ancillary probate. So what court actually oversees California ancillary probate?
So it's going to be the same probate courts that oversee regular probates here in California. It's going to be a division of the Superior Court. There are 58 Superior Courts in California. Each of them has their own probate division, and that division will oversee the ancillary probate.
So if the real estate's located in one particular county, then that particular Superior Court would then be the one that would oversee that probate?
You got it. That's right.
Okay. Now, are there different options to pursue an ancillary probate? In other words, are there different probate options?
Yeah, so in California, we have what's called a small estate, and that is all based on the value of the estate. And then we have what's just considered a probatable estate, which is above that threshold. And that threshold in California is $166,250.
So, yeah, and so by and large, if you have real estate in California, we're probably going to be in a formal probate because of the value of the property out there. So correct. The typical assets that are going to be probated in an ancillary probate are real estate. So what has to be filed with the Superior Court in order to get that process going?
So to start an ancillary probate in California, we need some documents from the original probate. And that's usually going to be the petition, what got that probate started, a copy of the will, and those need to be certified by that particular jurisdiction that's handling that original probate. And then we would file that with the court here in California, the appropriate court in California, and let them know that we do have assets here and that we need to do an ancillary probate attached to this original probate.
Okay. Now, do we file that petition by mail, and then do we have to go to court at some point then? Is that a hearing?
So yeah, we file that. We can we're doing e-filing in California a lot, so you can sometimes file things by mail. A lot of courts now are going to strictly e-filing, and so we get that filed with the court, and then they are going to put it on calendar and initiate that first hearing to address that petition for the ancillary probate.
And when we do that filing, do we have to give some notices to the beneficiaries or any creditors?
Absolutely. So we're notifying beneficiaries listed in a will. We're notifying heirs who may or may not be listed in a will. And we're certainly notifying creditors, both known and unknown.
Okay. If there is, let's just say that I didn't have to do any probate work in my state where the decedent died, and I now come to California because I've got to probate some assets that are in California. Does the filing process change as far as what I have to do in order to get that process going?
Not really. So it's going to come down to whether or not there was a will involved, and again, that's going to drive the probate process forward. If there is, if there's not, we're still filing that as an intestate process. But sometimes people have a trust in their home states, and maybe they have a vacation home in California that for some reason didn't get put in the trust. So we're looking that we don't have to worry about what's going on in the other state because there's no probate there, but we'll often look at the pour over will, which is usually accompanies a trust, and we'll use that to drive the probate for the California states.
Okay. Now, once I get my my authority from the court, what can I do with the real estate that's in California?
Well, so it depends on what kind of authority you get. Sometimes there's full authority, sometimes there's limited authority in California. But generally, the main thing that that person is responsible for doing is protecting that asset. And so you want to make sure that it's maintained, that the property taxes are paid, and that it's kept in good working order to distribute to the beneficiaries. Now, sometimes you can sell it during that process without court order. Sometimes you need to go get a court order if you want to sell it. Sometimes you're not able to sell it. So that kind of depends on each individual process.
So this kind of segues us into the next part of our discussion, which is to talk about the duties of the ancillary administrator. So give us a little feedback for the things they have to do. I understand they have to protect the property. What else do they have to do?
So yeah, it all comes down to their fiduciary responsibility. And so part of that is protecting the property, but it's also making sure that the finances are handled. So anything that is part of that estate, those are kept completely separate from any personal assets of the fiduciary, of the personal representative. Taxes need to be filed, so they want to make sure that the IRS is happy with the way everything's going. The state government is happy with everything's going, the county, all of those. So their job is to really kind of oversee all of the financial aspects of that particular asset and make sure that it's all handled like it's supposed to be.
Now, what kind of filings do we have to file with the court to inform them about the asset that we're probating?
So we're filing generally an inventory and appraisal. So that is an inventory of all of the different assets in the estate and an appraisal of what those assets value is. Once we file that, then the court knows exactly what's going on with that estate. And of course, then the beneficiaries also know exactly what is going on with that estate. And that's the important thing, is to get all of that out in the open.
Now, can the beneficiaries waive off any of these requirements?
They can. So a lot of times beneficiaries can waive them. If there's creditors, that may not matter as much. And creditors generally are not going to waive that. They really want to make sure that everything is matter of public record and that everything is above board. But yeah, sometimes the if the beneficiaries all get on board and if the estate is solvent, we're able to waive some of those requirements.
Now, and also, does the representative have to file an accounting with the court?
Yeah, generally, again, same thing. That's going to be generally the case. In certain circumstances, that can be waived, but that is almost kind of bringing everything together and wrapping up. This is what was spent on the estate during probate. So these are the expenses that were pulled out. It's letting the court know exactly what's happened, and then these are the assets that are still available at the end of all this to be distributed.
Okay, good. Um, let's talk about creditors. Okay, so it's the ancillary probate. There is a notice requirement, I gather, that needs to be sent off even in an ancillary probate. So
Absolutely.
tell us a little bit about that for both known and unknown creditors. How do we handle them?
Yeah, so again, that's one of the main responsibilities of the administrator is to make sure that all creditors are notified and taken care of. And so if it's a known creditor, we're sending them direct notice about what's going on, what the estate is, what that debt is that we are aware of, making sure that we're on the same page with them. And then we also publishing in the local paper, and there's a list of approved papers, and it all depends on where those assets are. And that's the paper then that we need to go and put a notice out so that any unknown creditors have at least some form of public notice that way.
And the notice itself, is that something that the court tells you what the notice should say, or is that something that there's a form about, or does the paper generally know what notice should contain?
Yeah, so it is a specific format that meets the legal requirements, and any of these papers that are pre-qualified to do this know what that format is. So
Okay.
generally, we don't have to worry about that. They're up on board with getting that done correctly.
And the purpose behind giving these notices, whether to known or unknown creditors, what's our objective here?
Well, so from a state level, the objective is to make sure that those creditors have the opportunity to make a claim against the estate and get paid. When we're representing a personal representative, really the benefit to that getting that notice out quickly is that there's a time limit for those creditors to make their claim. And if they miss that time limit, they're cut off. So it gets that clock started. And that's why we like to get notices out as soon as possible.
And what is that? That's important. And I know you've mentioned previously sometimes you will start that notice process even before you file that first petition. What is the time period that they have to respond and file something and make
So
a
they have
claim?
120 days to file a claim on the estate.
Okay. And where would they file that claim?
So that is a form that they would file with the court that is overseeing that probate.
Okay. And then what is the ancillary administrator, what does he do with those claims?
So they have one of three options that they can do. They can either pay it as it comes in. They can negotiate a settlement of that as the probate goes along, or they can deny it and say, no, this is not a valid claim. I'm not going to pay it. In which case, it's sort of the probate process can stop, and we have to basically litigate that to decide whether that is a valid claim or not.
Okay. Well, we've come a pretty long way from petition when we went through the process of hearing number one. We've given our notices to creditors. They file whatever claims they're going to file. We've dealt with those. We're eager to wrap this estate up, okay, this ancillary probate. How do we go about wrapping up an ancillary probate?
Yeah, so you're right. This is all the stuff that happens in between that first petition and the final petition is making sure that the estate is taken care of, all the creditors are taken care of, everything has happened like it is supposed to happen. Once we've gotten to that point, we're going to file that petition for final distribution, and a big part of that petition is laying out all of the legal requirements and letting the court know that we have satisfied all of those requirements and that we are ready for final distribution. And then we're going to give them a distribution plan and say this is is how we want to distribute that.
Now, we've mentioned before what I think is actually a very excellent strategy is that the courts have typically what's called a probate referee that generally gets involved in these probates for each judge, okay? Tell us a little bit about how the probate referee helps make sure that we get to that spot without any hiccups along the way.
Right. So when we are filing the inventory and appraisal, that's really where the probate referee comes in and earns their pay. So they're also getting a fee for their services, but they're looking at those assets and ensuring that they've been valued correctly and adequately before that gets to the judge, and the judge sees all of those final numbers.
Okay. And notices, if I'm filing petition for discharge or petition to close up the ancillary probate, who do I have to give notice to?
So you're giving notice certainly to any beneficiaries. If there's a will, we want to make sure that they all are on board and have notice of everything that's going on. We also give notice to any heirs, whether they're beneficiaries named in the will or not. They have a legal right in California to receive notice. And then creditors is the other big party that we want to make sure knows what's going on along the way, and they have a legal right to get notice.
So tell me, what is the typical time frame to do an ancillary probate in California?
So probate in California, whether it's ancillary or regular, you're looking at close to the same time frame. And the average probate in California right now is just under 2 years. So it can be a substantial time commitment. Usually in a best case scenario, you're looking at somewhere around a year. If things get messy, and there's a lot of creditors' claims that are being disputed, it can drag out into years and years and years. But right now, the average, like I said, is right around 2 years. So that's kind of a good idea of general ballpark where you'll be.
Okay, so let's talk about ancillary probate. Means that we have assets that we otherwise didn't put into our revocable trust. Okay, most folks have the revocable trust, but if I have to go through and do an ancillary probate, what kind of fees are we typically looking at as far as attorney fees and other costs?
So attorney's fees in California are statutory, and there's a really convoluted formula on how we get there. And if you want to ask me about that, I'm happy to talk about it. But I'll just say that it's a formulaic for attorney's fees, also for executors' fees. Same formula is involved with that. And then there's just a lot of the filing fees. Like I said, the probate referee gets a fee. All said, you can basically count on somewhere between 5 to 10% of the value of the gross estate to be the fees that you have to pay to get the assets through probate.
Okay, so let's talk in terms of ancillary probate. If I have California real estate and I'm a non-resident decedent, what could I do or could I have done to avoid this ancillary probate of the real estate?
Well, you've already mentioned this, and you're absolutely right on. The very first thing that I would tell somebody to do is, and particularly with real estate, but really any asset, is get that in a revocable living trust. Anything that is properly titled in a revocable living trust upon the trustor's death is exempt from probate. So that's the first thing, is to avoid it by doing it that way. There are some other ways that you can do it. In other words, hold it in joint tenancy with another person. California is a community property state, so oftentimes that property is going to be community property. Those will avoid probate on that first person's death, but if all of the joint tenants or all of the community property holders have passed, that property will still go through probate at the end of that. So hands down, the best way to avoid probate is to put those assets in a revocable living trust.
So I think, and I agree with you, and of course I think we want to emphasize that doesn't mean that you list the asset on Exhibit A to your revocable trust. You actually need to get a California deed prepared and convey it and get that deed recorded in the land records. Is that right?
Yes, sir. That is absolutely right. That is what determines ownership. It's not what we wrote in the trust, it is how that particular asset is actually titled. And for real estate, that is what is on the deed that is recorded with the county
Okay,
that the asset is in.
sure, sure. So I want to kind of segue to, I have California beach property. I'm a non-resident. I live in Virginia, and I've done all my estate planning documents, and I have a revocable trust. Okay. I now decide that I'm going to go ahead and sell my property and a house in Virginia, and I'm going to go to California. I want to be able to do some surfing, and I want to enjoy that good warm weather in the sunny skies of California. I show up in California with my Virginia revocable trust. So if I want to make changes to that trust, can you as a California lawyer really help me?
Yeah, so first I'm going to say, welcome to California. We're glad to have you. But then we're going to look at all of those documents. Virginia trust does not necessarily need to be changed because you move to California. We have an agreement of reciprocity with Virginia that those trusts done there will be valid in California. However, I would definitely recommend you have a lawyer look at it because there are differences in California law and Virginia law, and we may want to do some amendments or do something to tweak it to make sure that it is going to work like that trustor wants it to work when it is necessary. So that's important to have. May not necessarily need to be changed, but I would always recommend having an attorney in that new state who's licensed in that state look at it to make sure that there are no problems that they can see that could pop up and derail things.
Okay. And of course, the document would say that Virginia law governs. So if you're going to do an amendment, then I think what we would do is certainly change the governing law to make it California so that we would actually be able to have things be able to be looked at by a California attorney. The other documents that always come into play is I have a will, pour over will. In Virginia, we have self-proving affidavits, so we have all that stuff going for us. We show up in California with my self-proving pour over will. Do I need to do anything with that document?
That's going to be very similar to the trust. As long as that document is valid in Virginia and governed by Virginia law, again, it may not need to be updated because, especially if it's a pour over will, because really the idea of that is that that's going into the trust anyway. So we'll look at that and make sure that that is going to do what we want it to, which is to put any assets not in the trust over into the trust. And then we're going to focus on that trust to make sure that that is distributing those assets according to the trustor's intent.
Okay, so the other two documents that are really important is the durable financial power of attorney. So we have, we have these lengthy documents. They say Virginia law. They cite Virginia statute to grant all kind of powers by incorporation. I show up to California with my Virginia power of attorney. Am I going to be able to really use that in California, or should I have that redone?
Well, I'll be honest with you, in California, I'm on the phone a lot with financial institutions who have a problem with a California financial power of attorney. And I usually have to talk to their legal team and get that going. So for a power of attorney, the durable financial power of attorney, I would say, yes, you can save yourself a lot of headache by redoing that under California law. And again, it's not going to eliminate everything because those are troublesome for financial institutions. But as troublesome as they are when it's a California document, I can only imagine how much more trouble you're going to run into if you leave it as a Virginia document. So that is definitely something that I would want to have changed over if it was me moving like that.
Certainly, and of course, a lot of times people use the financial power to do transfers of assets into revocable trust. So if you're showing up at a bank, you may find that you hit a roadblock. The last one,
Absolutely.
which would actually be very important, of course, is the medical decision-making document. Written under Virginia law, I show up and now I go into a hospital. I need to have something, and I present this Virginia healthcare power of attorney. How are the hospitals going to react to that?
Yeah, so that could be another issue. And California, in particular, out of many states, has some very strict rules and laws regarding those documents. and what can happen with those documents. And so again, once the hospital gets that, it could throw them off because they're not used to seeing that. And if it does not meet what the laws say here in California, that could be a problem for you. So that's another one of those documents that I would recommend that you probably amend or update. And in fact, you don't amend those. You would just redo a complete new one so that it complied with California law. And that's generally going to save you a lot of grief in the long run if that document ever needs to come into play.
Okay. Well, we are quickly running out of time, Mark. I wanted to at least give you an opportunity to kind of share with our audience, some lessons you've learned over the years as far as ancillary probate, some tips and advice about things they should do and shouldn't do. And I know you've mentioned a bunch of things, but I wanted to give you a chance to kind of capture a couple final points for our audience.
Okay, thanks, Richard. I guess the big thing, I'll just reiterate, if you can avoid probate at all, do that. And that's mainly going to be done through a revocable living trust. So you want to get that set up and you want to make sure that it's properly funded. And then the other thing, if you are in probate and you are acting as the personal administrator of that probate, just a couple of things. Really be diligent, keep good records. That's going to be the saving grace. And then good communication. Communicate with the beneficiary so that they know what's going on. Certainly communicate with your lawyer when they need information from you, and communicate with the creditors. And as long as you do that, you're going to be okay getting through the probate process.
Mark, thank you so very much. On behalf of the Probate Nation, you've just done a wonderful job, just sharing with us, both an overview of ancillary probate in California as well as giving some great advice about things to do if you have to do an ancillary probate. This valuable information, a great public service for our viewers, and I want to, again, thank you for taking the time to help us learn all about this.
Well, thank you, Richard. Absolute pleasure to be with you again.
Thank you again. You're very welcome. Without a doubt, probate can be complicated and time-consuming, and this is especially true if you need to probate assets in another state through a process called ancillary probate. Many non-residents of California own second homes in California, especially beach houses. And our show tonight introduced you to the process that will need to be undertaken should you need to probate that California home. While the process seems consumer-friendly, I would be remiss if I did not emphasize the importance of consulting with a local California attorney about any ancillary probate you may need to undertake. The guidance of an experienced professional will help you avoid unnecessary work and pitfalls for the uninformed, while shortening the time you ride the ancillary probate train through the sunny beach towns in California. I hope you found the show helpful, and remember that replays of this show and all the shows today can be viewed on the Probate Nation website and soon on the Probate Nation YouTube channel. This brings us to the conclusion of our show. On behalf of the Probate Nation, thank you for visiting with us.